Under Section 271 of the Delaware General Corporation Law, or DGCL, corporate shareholders have the right to vote on a proposed sale of all or substantially all of a corporation's assets. In determining whether a proposed sale constitutes substantially all of a corporation's assets, Delaware courts consider both the qualitative and quantitative nature of the sale. In Katz v. Bregman, the Delaware Chancery Court considered whether a corporation's sale of its assets owned by its Canadian subsidiary constituted substantially all of its assets. Plant Industries was a Delaware corporation that produced steel drums for use in bulk shipping and the storage of petroleum products, chemicals, food, and other products. In 1980, Plant, under the guidance of its chief executive officer, Robert Bregman, began selling several of its corporate subsidiaries. In addition, Bregman began negotiating the sale of Plant National, which we'll call National, to raise cash and improve Plant's balance sheets. Plant also planned to move away from its steel drum business to make plastic drums. National was Plant's entire Canadian business operation and only income-producing facility in the previous 4 years. In fact, in 1980, Plant's Canadian operations represented 51% of its remaining assets and 45% of its net sales. And in the previous 5 years, National accounted for 34.9%, 36.9%, 42%, 51%, and 52.4% of National's pre-tax income. Following negotiations, Plant entered into an agreement to sell National to Vulcan Industries. However, before entering into the agreement, Plant received a higher offer from Universal Drum Reconditioning. Nevertheless, Plant rejected the offer because its board believed that it couldn't negotiate with Universal since it had already entered into a firm undertaking with Vulcan. Subsequently, In Katz, a Plant shareholder, sued Bregman and others in Delaware Chancery Court for a preliminary injunction prohibiting the sale of National to Vulcan. In the action, Katz argued that the deal with Vulcan constituted a sale of substantially all of Plant's assets. As a result, Katz contended that the sale could only be accomplished by an approval vote of a majority of Plant shareholders at a duly called meeting with at least 20 days' notice.